We are here this afternoon for two oral arguments, and the first one is Teig versus Chavez et al. Mr. Teig, you may begin.
Thank you. Good afternoon. And at council table with me is Thomas Story. I appreciate the court's indulgence. He was the attorney for amicus brief, so I appreciate him being allowed to sit at council table. Thank you. May it please the court, Bob Teig. I haven't done this for 14 or 15 years since I retired, and I really appreciate this opportunity because Iowa has a problem with violations of its public record statutes. That's not just my opinion. That's what legislators think. I read over the weekend a Gazette editorial that said there's a statute in the legislature now to increase the penalties for these violations by 400%. Evidently, it's a big problem, and I don't know if a new statute will solve the problem or not. But there are things this court can do to breathe some life back into the statutes that we have that will solve some of those problems. Now, the state and local governments, day by day, bit by bit, are choking off the public's right to access, and they don't do it through the courts.
Like you have four main issues from my review. Which one, if we were only able to talk about one issue today, which one do you think is your best argument?
Not one that's a slam dunk, but it needs to be discussed because it never had. Yes, the attorney-client one. There is no attorney-client exception under Chapter 22. There is one for work product, but not for attorney-client. The fact that the legislature put in work product but not attorney-client, that means something. So there's no statutory exemption. There is no other statutory exemption for attorney-client privilege documents. 62210 is a testimonial privilege for attorneys, has nothing to do with documents. So there's no other statutory.
For years and years as, in effect, codifying the common law attorney-client privilege.
Chapter 22, you haven't.
Actually, I would disagree with that. I think I wrote Horsfield and I said, the act, this is referring to the Open Records Act, does not affect other specific statutory privileges recognized by the legislature, such as the attorney-client privilege.
Was not a holding. And
are you going to press that argument? Are you saying there's absolutely no attorney-client privilege with respect to any government entity covered by open records? Even a litigation, attorney-client in litigation, not work product?
Chapter 22, there's no privilege. And I'm not saying it, legislature is. And you can't use the common law.
You started by saying no. Are you saying yes, there is absolutely no privilege?
Absolutely no attorney-client privilege for Chapter 22 record access.
And if I'm missing something in the statute, please feel free to correct me. I assume the public defender's office is covered by Chapter 22. Is that correct?
I don't know, but all right.
That somebody can file an open records request and get attorney-client communication from the public defender, from the county attorney, from the attorney general's office, from this court? If so, I want to know that.
No, because the public defender is involved at the litigation stage. That information is all going to be work product. It's all protected. They're different, and here's why they're different. In fact, this court hasn't even recognized attorney-client privilege for governments. In Tice, it's only recognized work product privilege. Well, we don't have to get to where it's recognized or not. We're looking at the statute, and we have to go by what the statute says. No one has ever pointed to me where it says in Chapter 22 that there's a privilege for attorney-client.
keep going. I mean, this isn't, I mean, people are very loosely use the term dicta. It wasn't dicta what I wrote in Horsfield, Mr. Teig. The issue in the case was whether there had been a violation of the Open Records Act by the city because it initially withheld certain 8 emails, but then subsequently waived the attorney-client privilege and released them. And I held the city had a right to withhold the emails. While there may be circumstances when it is unfair for a litigant that has properly asserted the attorney-client privilege later to waive the privilege, this is a procedural matter and not a violation of the Open Records Act. That's a holding. That's not dicta.
There was a privilege, and then said they can waive it if they want. Didn't say there was one. Sorry, my reading. So, and that wasn't an issue, whether there was one. The issue is just what you said, whether pulling it.
Issue was, does the Open Records Act give way to the attorney-client privilege? And I said in that case it did, and I was joined by the rest of the court on that.
Well, then I go to the next step. It was wrong, and this court has an obligation, like any court, to fix its mistakes. And the reason I'm asking to do that is because what this court calls the organic nature of the law. I wasn't there, but I'm willing to bet that no one argued there was no privilege. But now, because of the organic nature of the law, it's being argued, and it's being raised, and it's being questioned. So it has to be looked at.
Work product client privilege. So you would agree, right, that once litigation has started, not every lawyer-client communication is work product. Work product is a specific subset of documents created in anticipation of litigation, correct?
Or in connection with, yes. Or discussions.
Product. Even when litigation's commenced, you're saying the attorney-client communications that don't fall within the work product doctrine are subject to the Open Records Act.
Communications relate to the litigation. They're still work product, even if they're not documents. The communications are the matter, however they exist. In documents, recorded, in memory, it's the communications related to the litigation. And here's why that's important with governments. Government all the time talk to attorneys, and those discussions have nothing to do with the purpose of the privilege. The purpose of the privilege is to encourage communications. It's to help resolve problems. This communication, we haven't seen it because it hasn't been disclosed, but evidently it's the attorney saying, if you do this, you're fine. Now, there's no reason, my wife asks, why don't they want to turn that over? What's wrong with that? And that's why. That doesn't meet the ultimate purpose of the attorney-client privilege.
Opinion fall into the work product exception that's expressly included in Chapter 22?
No, because it wasn't related to pending or imminent litigation. I had made the record request, and my understanding, because I haven't seen it, my understanding is it says you don't have to turn it over because it is a confidential document.
For a record and then that entity going to their attorney to determine whether or not that is something that needs to be turned over. Is that not in anticipation of litigation, which is what we're in right now?
Hope is they're going to turn it over and not have litigation.
If they have a valid, at least dispute about whether or not it's something that should be turned over, and then they go to their attorney to get advice on that, and then their attorney is like, no, my advice is, no, you don't need to turn it over, and then they don't, is that not then in anticipation of litigation, because then that person, such as yourself, then sues the entity to get the record?
Advice wasn't obtained because of anticipated litigation. The advice was obtained because of a request for compliance with the statute. So it doesn't really relate to the litigation. I think it's a step far removed.
Can I ask you about your argument under 22.31 and the reasonable expenses? Why doesn't the city's policy comply with that statute?
because the statute doesn't authorize general search and retrieval fees. I know that's what happened back with Rathman, but the law has changed. The language Rathman relied on, the legislature got rid of it. And now it says the fees are for examination and copying. Examination has nothing to do with retrieval. There are specific...
Copy something without finding it, without retrieving it. I mean, it seems like it's part of the same thing.
How are we going to go? We're going to say you also have to pay for the production, because how do you copy it if it's not produced? We have to go with what the legislature said, and that's their policy choice. They could say, yeah, all right, how do you copy it without producing it? You have to pay to produce it, but they don't. They say that generally the presumption is examination without charge unless authorized. And there are 4 sections. What?
Left out the part of that statute that says, for a record which takes less than 30 minutes to produce, which infers that if it takes more than 30 minutes to produce, then you can charge them for those costs.
For a copy to be produced.
I'll go back a little bit further. The lawful custodian shall make every reasonable effort to provide the public record at no cost other than copying costs for a record which takes less than 30 minutes. So even within the 30 minutes, they can charge for copying, but they can't charge for producing. Which leads me to infer that if it takes more than 30 minutes, then you can charge for producing.
It's copying, not giving. Because you have to look at the beginning of the paragraph, which talks about fees for examination and copying. And all the language talks about you can have copy fees, supervising examination, but nothing about going back before examination. If we infer fees, you read the presumption of free access out of the statute. You repeal it by implication.
Sure, I understood. Did you say it's your argument that production does not equal providing?
The production in the statute means producing a copy, making a copy.
Handing it over? I thought you just said something about its own. It does not mean providing, it just means copying.
Yeah, yes, in that sense, producing doesn't mean having it here to examine, because I can examine it for free. I don't have to request a copy. So that would never kick in. I'm entitled to take my phone in there and make my own picture, and they can't charge me.
Then when you're asking them to be the one to produce it, then they can. It talks about copying and producing. It talks about those as two different charges.
That's why you're here to parse the language. But see, that's the problem. We're parsing language to get there, where all the legislature had to do was say, you can have search and retrieval fees, like they did in 4 specific sections in the code.
Almost up, and I would like for you to touch on, for just a couple minutes, the argument that you have regarding the job applications, and in particular, I'm curious about Jacoby and Van Sloten already being city employees at the time of their apps. What's your best argument for that? Because you got like a minute and a half.
The legislature defined the statute differently from when it was with City of Sioux City, so they superseded it. Basically, the city of, when Sioux City was decided, it said, if you're outside government, it's secret. A job applicant would have been. Legislature now says, if you're applying for a contract, you're not outside government. They have now defined the term outside government that supersedes City of Sioux City. That's pretty plain language. So that's the big distinction there.
To the applicants who are already working for the city, so it would not apply to Ms. Chavez, who was working in Wisconsin?
It says either if you are currently have that relationship, or if you are communicating in connection with a contractual. And anybody applying for a job is applying for a contractual relationship. So it covers all applicants. It's a wide net. It gets them both ways for some people. But it makes sure it treats them all equally, which is only logical. You wouldn't want to treat one applicant different for another.
Address a separate issue about the reasonableness of the time in which a government entity can respond. Well, and here is my question for you. As a court, I think there is a practical concern, yeah, it's fine, of not treating reasonableness necessarily as a fact issue that has to be determined in every circumstance at trial, because there's just some very practical considerations about government entities responding to these requests. So give us kind of a framework where we can create a standard that protects people's right to get access to records in a timely fashion, but that doesn't bog every government entity in the state of Iowa down in litigation about reasonable delay.
You can do lines, it's great. Should follow the suggestion was promptly meant when you go there and ask. That's the threshold where someone can seek enforcement. And then the question is whether it's a violation. That's a factual determination. And in different circumstances, it's going to mean different things. Now, if you do it that way, it's going to encourage people to talk to each other. If the city knows, for example, they came in now, I have to give it to them now, or we might be in litigation, so they'll talk to them and they'll explain. See, I didn't get those explanations. They wouldn't tell me. They didn't have to because they could just say no. It also will set up the burden of proof so it matches with who has the evidence. And when you get to, if it comes down that they can't work it out because they've been talking because they had to, then if it works out that it was just impossible, that's a defense to a violation. So this is the way to accommodate it for everybody. Otherwise, the city has no incentive to turn records over. It's, no, you don't like it, sue us, and most people can't do that.
Justice McDonald is, okay, you're done with that line? Okay, thank you. Your time is up for this time, but you get to come back around in a little bit.
May it please the court and counsel, Andrew Tice of the Allers and Cooney Law Firm. This appeal, I think, highlights the peril of public service. We have 6 individual public servants here who are now defending a lawsuit seeking monetary and injunctive relief, and they're doing it in a situation where they followed this court's precedent. In preparing for today, there were 7 different issues that were briefed, and I'm trying to figure out which issues we're really going to talk about today.
Why don't you explain to me what language in 22.7 allows the withholding of Ms. Jacoby's application to be city attorney?
Primarily looking at subsection 18, which would be the one that this court obviously addressed in the Sioux City case.
Government, by identified persons outside of government. She works in government.
So you're going right to the core, of course, of the issue that this court was looking at also in the Rippinger case, is what does that new definitional language mean?
Rippinger, we remanded, so.
Start from the position that we have the Sioux City case. So we know that we had an authority going back to 1988 that says these job applications are going to be confidential. They don't need to be produced. It's a valuable incoming communication that we don't want to dissuade by scaring people off, making it public. When the legislature comes in and amends its statute, it doesn't do anything to say that we're trying to change that precedent. It doesn't address job applications, and it doesn't address the legislative concerns and goals that this court set out in Sioux City.
Have the language of the statute outside of government. She's not outside of government. I mean, it doesn't strike me that the world is going to fall if her job application is released to the public. I mean, when I applied for this job, my application was released to the public.
Obviously about one person, we're talking about precedent setting because For the last 30-some years, these have been confidential, and everybody knows that when they do it, that it can be confidential.
That's the case. I mean, you're representing that. I know your firm represents a lot of municipalities, but I don't know that that's true.
The Sioux City precedent that says these are confidential. So municipalities or various forms of government can withhold these, so people can apply knowing that these are going to be confidential. I understand you're looking at the new definitional language. I just wanted to start from the point that I didn't see anything in the statute that indicated the legislature was purposely trying to overturn the prior precedent to say, now we're going to make applications public by enacting that statute. Now, when you say outside versus inside government, I think we look at the statute. We know that previously, when that same verbiage was still in there, outside of government, that this court said, well, those job applications are still going to be confidential, but now we have a definition.
I don't think that that issue was contested in Sioux City, though, was it?
In the decision that that was a disputed point, but the language was there.
That we addressed it one way or the other.
True. If we look at the actual language, though, I think the question is, what does it mean to be a person outside of government? So our position would be that even for somebody like Ms. Jacoby, who is presently an employee, she is a representative of the city of Cedar Rapids. When she applies for a new position, she is not doing that as a representative of the city of Cedar Rapids. She's doing that as a person. It's outside the course and scope of her employment. There's no evidence in the record here of any job responsibility that she would have to seek out or apply for a different position. So when she did that on her own. I would liken it to the situation where we see people that would file suit in civil litigation, and sometimes they sue people as an individual, and other times they do it as a representative. If somebody's doing it within the course and scope of their employment, they're doing it as the person inside a government, as a representative.
That they added to define that, there are two different parts of it. One kind of does go to within the scope because it talks about communicating with respect to a consulting or contractual relationship. But then the second part of it says, or who are communicating with a government body with whom an arrangement for compensation exists. And so can you say that Ms. Jacoby did not already have an arrangement for compensation with the city?
She had an arrangement in place for her employment, not for the position she was applying for.
Doesn't that seem to be a distinction between, the first part of it does seem to be communicating with respect to that relationship. The second one seems to be much broader.
See, the term existing comes after the arrangement for compensation. The prior reference to having a consultant or contractual relationship, I guess in my reading, I would view that as this was a legislative attempt to address what would be contractors or construction outfits, things like that, having communication to say, well, now wait a second, that's not going to be confidential because that's part of the public fisc. If there's communications going to what's a little funny about the analysis here is I think that if we look at a situation where, let's say, there's an outside construction company working with a city, we would typically view them as being outside the city. But what we have here is this thought that, well, no, maybe that was inside the city, and now the legislature's telling us, no, it's not. No, it's not. Those people are going to be outside. I think that was intended to address that situation where a city is paying this outfit public money, and so the public has a right to know about communications that are going on. In this case, we talk about Ms. Jacoby. She's presently employed. The public has a right to know about her current compensation and would, but they don't have a right to know about the position that she's seeking, where there is no such agreement in place. So I don't think that they would have a right then to see the application that historically has been confidential.
So it's your position that even before the change in the legislation to specifically define, and it didn't just define, and it just says who's not included, that under Sioux City, that even then, that the outside the government did not apply to current employees who were seeking a position within the same government body.
If I got confused on the subject, no, I'm saying that historically, the person would be outside of government because they were covered by Section 18.
Government, even though they worked for the government, you're still saying that they were considered to be outside the government.
And that they're personally seeking a position outside the course and scope of their employment, yes.
Then Sioux City, is there any other case that supports that?
Not that I'm aware of, no.
I mean, it seemed like the rationale in Sioux City was a concern that somebody from outside or from a different city that maybe applying and, hoping to get the job, but didn't want their current employer to know they're looking around, would appreciate and expect privacy. But if it's an employee within the city that's applying for a different job at the same city, their employer's going to know. So that rationale doesn't fit.
Correct, Your Honor, in the sense that that was the issue that was addressed specifically in the Sioux City case. And that, I think, is kind of the low-hanging fruit. It's the obvious issue out there that, yes, I don't want my current employer to know I'm seeking employment elsewhere. But I don't know that it's all that hard to conceive of a situation where even with, say, somebody at the City of Cedar Rapids, they don't want the public to know, or their colleagues at their employment to know that I'm looking for a different job until they've got it. So.
Issue of how we calculate and measure what's a reasonable time for responding to open records requests?
Difficult question. It's hard to grab on to something objective or quantitative. I think there is a section of Chapter 22 that will address time periods of either 10 or 20 days. I think that was in 22.8, if I recall correctly. It's not a hard deadline by any means. I think even this court has been clear in the past that there isn't such a hard deadline for a response. There's just been kind of this as soon as feasible, prompt, and I think the implied reasonableness, which does raise the issue you raised previously during this argument, of course, that when does that become a fact question? I think there could be times where that could be a question. This court's Bellin versus Reynolds case, I think, presented more of the extreme. We're talking about years worth of time. And in this case, we don't have anything from the lower court that kind of laid all that out, because here we had much, much shorter periods of time, and we had a public body that was interacting, not just sitting back on its heels until it got sued.
Does that matter in terms of, if we're looking at kind of the overall response, rather than looking at the absolute amount of time, should we be looking at things like, was there interaction, was there back and forth, or are we just measuring time only?
The issues, because my reading of the Bellin versus Reynolds case suggested to me that that was an issue. I thought there were various factors that could be considered. That issue, of course, being whether or not there was an implied refusal. I don't know that you and I are dialoguing about implied refusals, or if we're just talking about what's a reasonable period of time. So I think that if I'm looking back at that case, yes, it looked to me as though this court was concerned with whether there was efforts to fulfill requests or explanations provided.
The attorney-client issue, we did cover, it seems like, Chapter 22 in Horsfield, and say that attorney-client privilege in 622.10 includes all communications with respect to Chapter 22. When we did that, did we overrule Tice or some of the language that we used in the Taz or Tice case, however you say that?
All there having been any overruling.
It wasn't explicit, but there was some language in the Taz case that talked about that with respect to cities, even though a government entity is entitled to claim the attorney-client privilege with respect to some communications, we talked about the privilege being circumscribed, and we needed to look at it with respect to open records and open meetings, and we need to look at it on a case-by-case basis. Did Horsfield walk that back?
I don't know that it did. I only remember slightly what you're referring to, and that there could be circumstances where the attorney-client privilege might be something that's not confidential anymore. I apologize. I read the Horsfield materials case, and I looked at that and thought it's fairly rare that I have cases on appeal here that are just so clear in the prior precedent directly applicable to what we're talking about here.
Cited in your opponent's case, so, or in his brief, but you didn't look at it.
I'm not saying it wasn't, of course. And I don't
Slam dunk for you.
use the word as I heard it already today, but I thought it was. In fact, it's somewhat rare that I'd be here and I'd look at the 7 issues and think, well, I view them as being three big ones, and on all 3 big ones, it looked to me like this court has spoken fairly definitively. When we have the attorney-client privilege, it's Horsfield. When we have the job applications, it's a Sioux City case, and when I looked at the retrieval fees, it looked like the Rathman case. I mean, all of them.
Cases that talk about 622.10, are there cases that identify the fact that that statute specifically says in giving testimony? And
I've just looked at that one case.
Well, aside then, I mean, if the statute says that an attorney is privileged in giving testimony, does that extend to the broad attorney-client privilege that we recognize in common law?
So when I looked at the Horsfield case, when it says that the Open Records Act does not affect other specific statutory privileges recognized by the legislature, such as the attorney-client privilege, I think 622.10 clearly recognizes the attorney-client privilege. There's a reference to it as being testimonial, but I don't know that we have to view it so limited. I think that statute very clearly acknowledges it.
About there's a common law attorney-client privilege, and then there's a statutory attorney-client privilege that was testimonial.
And it references the testimonial. And I think that the privilege, of course, itself is, we've cited cases that say it's an ancient doctrine and probably one of the more revered standards, I think, that at least in my practice we look at. So it's well recognized. The question is just where to.
And two, pass a statute that said that with respect to public entities, there is no attorney-client privilege?
It's within constitutional boundaries. I don't know what would limit the legislature. I just don't see why it would ever do such a thing. But I do think that in this case, I would be stunned if the legislature purposely stripped all public bodies in the state of Iowa of that privilege without even saying that that's what they're doing.
Yeah, with a law firm that frequently represents cities, what would be the practical effect if we were to accept Mr. Teig's view of that there's no attorney-client privilege for opinions and documents? And
disaster, because we can look at it whether it's the kind of advice that comes in the context of litigation or claims, or even outside of that. Inevitably, there's going to be many, many legal opinions that are given to public bodies that may, in the end, advise with regard to different courses of conduct. And if that's all made public, then cities are just going to get sued to oblivion, is what I would think.
It's Minnesota, actually. I mean, there are other states that recognize that with respect to public bodies, that
Privilege whatsoever?
not outside of litigation and related to litigation, yes. But with respect to just general, as a public body, what can I do? Give me some legal advice. Those are not necessarily all protected.
Looked at the other states to see that they've done something like that. I'm just glad ours hasn't.
Do you think there's any, putting Horsfield aside for a minute and just looking at 22-4 and the legislature's use of the work product terminology rather than the attorney-client privilege, should we worry about that at all, as your opponent suggests, or?
Subsection that does include confidentiality for a work product. Yeah, I mean, I think that's the thrust of the plaintiff appellate's argument here, but do I think it's concerning? No. I think it was an acknowledgement by the legislature that those kinds of issues could be things that should be kept confidential, but I think that we obviously have other reasons why attorney-client would be part of this whole umbrella for very similar thoughts. I see that my time is about expired. Thank you very much. We would request this court affirm the district court's dismissal.
Thank you. Privilege in section 622.10 is limited to disclosure of confidential communications by the giving of testimony. It's the McMaster case. So it is.
Seems to say something different, though.
And other cases do as well, don't they, Mr. Teig?
I haven't seen those other cases. I don't know what you're talking about there. The cases I have seen cited say you have to construe the statutory privilege strictly, and it only applies to testimony. Otherwise, why does it only say testimony?
I don't know. They say, I think the cases just kind of lumped together. We also have a common law privilege, and we recognize it as very important, and then don't really talk about the statute very much.
It's kind of what we were talking about. It's clear the legislature could do away with the privilege. Is there any disagreement about that? It's a common law privilege. Legislature could absolutely pass a statute that says we don't recognize it anymore. It's not constitutional.
Horsfield. And the legislature hasn't done anything since we passed.
The point is, the legislature could eliminate it, but the question here is whether the legislature recognized it by statute. Because we can discuss the policy all day. It doesn't matter what we think about policy. It's what the legislature decided. And if they decided it's not included, they didn't put it in there, although they put in work product, why would they leave this out? Because they know the difference. It's not in 622 for documents. Why would they not put it in there? They know the difference. If the legislature made that policy choice, maybe it's dumb, doesn't matter. That
There are other cases that say besides horse,
right. And but they don't discuss the full privilege. It's like anything. Documents weren't the issues in those cases, and we all know if the issue isn't.
Or partly in contrary, yeah. I mean, and Taos was an open meetings case, and I think what the court said there was that, you know, you can't like use these closed sessions and claims of attorney-client privilege to prevent people from, you know, in effect circumventing the open meetings law. But that's not an issue here. Nobody's talking about open meetings. We're talking about open records, right?
The other thing, Taz didn't, the issue was whether it's privileged, and they didn't recognize the full privilege.
The fee issue. So there's an argument here that we really can't resolve the fee question in this case because you're challenging the city's policy, and the city is not a party to the litigation. And I don't understand really what the response is to that. So if you could help me clarify that, that'd be great.
Of relief. So it's telling the individual people who are in charge of asserting, participating, saying, you can't charge fees. That does the same thing. We don't sue the city because why do we want the city to pay the city for a violation? Makes no sense. The city acts through its individuals, so that would be part of the injunctive relief.
Joined these named defendants from collecting the fee, why can't the city just have a different cashier or clerk collect the fee who's not enjoined?
Because this court, if it enjoined them, would say, you can't charge fees, you're enjoined from doing it. I can't imagine any employee saying, wait, this court said I can't charge fees, I'm not doing it.
It only enjoins the parties who are subject to it. If you haven't enjoined the city from doing it, it can act through other agents who aren't specifically enjoined. I don't understand that.
But no, the law says that fees can't be charged. That's why these people were enjoined. The law would say, you can't charge fees, you are enjoined from charging fees. This person isn't going to say, wait, that says I can't charge fees, I'm going to charge fees. Nobody's going to do that because they would know they'll be next. So that's how it works. I know I'm way over time.
Hitting the button. Okay, you can give a closing sentence.
Thank you. I ask that this go back to the court to complete discovery and that we get a trial and you put the life back into these statutes that over the years, it's changed. And this is the chance to recognize those changes you haven't had before. Thank you.
Teig versus Chavez is hereby submitted.